commenced in 2025, which will automatically apply the rules effective on that date. And to pursue this case, rely on funding from two outside third-party funders, namely ATJ Funding, who has a reputation of an aggressive rough funder, and LeadSure, whose funding details are completely in shadow. Therefore, respondent has two submissions. First, the SIAC Rules 2025, and even more, previous cases such as Car & Car versus Volkswagen also show that specific version should be identified by name and using general words. But in this case, if the parties intend to adopt the rules effective on the contract date, they could have included the clear expression of SIAC Rules 2016, etc., instead of using the ambiguous wording. However, in this case, neither the formal arbitration agreement text nor the negotiation history refers to any specific version, and therefore, any reasonable person would have the understanding that the arbitration agreement is to apply SIAC rules effective on since the arbitration was commenced in 2025, and there is no specific agreement on the applicable version, SIAC Rules 2025 shall apply. And if the tribunal has no further questions, I may move on to my second submission. Thank you, Mr. Arbitrator. Well, respondent in this case is a successor of Botanical Garden, and respondent resigned the contract to replace the old contract between claimant and Botanical Garden, and indeed, some of the obligations in the old contract is binding to respondent. But however, such obligations when the respondent know or could not have been unaware of such obligation. And this is confirmed by Article 8, Paragraph 1 of CISG. Since my time is limited, could I ask for 1 more minute so that I can wrap up my second submission?
Yes, 1 minute, please.
Thank you, Madam Arbitrator. So for the second issue, respondent submits that the tribunal should order claimant to disclose the third-party funding agreement, not just according to Article 38, SIAC Rules 2025, but even under the 2016 version, the tribunal still have the power to do so, as according to Article 27 of the 2016 version, the tribunal would have the power to order document production, and such include to order the disclosure of third-party funding agreement as the official practice note issued by SIAC confirm such position. And the tribunal should exercise such power because the criteria of third-party funding agreement disclosure relevant reality are already met in this case. The third-party funding agreement and the litigation insurance agreement is relevant and material to this case because they are essential for both the tribunal and the respondent to evaluate the financial position of claimant and the third-party funder's obligation to bear adverse costs, and such information is critical for the potential security for costs. And furthermore,
okay, I think time is up.
Thank you. And that will just conclude my submission. Thank you.
Okay, before we go ahead, may I ask the secretary, like how do we timing these two players? Do we have a countdown timer?
The my leader tell me that one of the co-arbitrators should do the time limit job, and I don't
Yeah.
know the.
Okay, can I do it? Because I can actually set a timer in my at my end, and then I think all of you can see it from my screen. Let's see, because I've add 1 minute more to the respondent, so now I'm granting 15 minutes for the claimant. Okay. I
Okay,
think
that's
now,
very
can you see
great.
that?
Oh, yes, yes.
All
Thank you
right,
so
all right.
much. Mm.
Okay. All right. So now let's have claimant, please.
Okay. Madam Presiding Arbitrator, members of the tribunal, opposing counsels, good afternoon. My name is Ke Xinhuang, and I will be presenting on the procedural issues on behalf of the claimant, Workis Worldwide, Ltd. With regard to the procedural issues, claimant has two submissions. First, the arbitral tribunal should apply the SIAC rules 2016. Second, the tribunal should not order the claimant to disclose the agreement under the SIAC rules 2016 or Rule 38.4 SIAC Rules 2025. Honorable Tribunal, claimant bases the first submission on two considerations. First, both parties reached an agreement on the application of the SIAC Rules 2016 in the arbitration clause, and our entire submission rests on the fundamental principle of arbitration, party autonomy. The core of this dispute lies in the interpretation of the word current in the arbitration clause. The contract was signed on August 25th, 2022. Therefore, the current must be interpreted as referring to the rules in force on that date, namely the SIAC Rules 2016. This interpretation is not only a matter of plain text, but is also confirmed by the context and the both parties' conduct. The unit joint principles of international commercial contracts 4.1 explicitly states, a contract shall be interpreted according to the common intention of the parties. Therefore, in this case, claimant respectively requests the arbitral tribunal to examine the intentions expressed by the parties through the contractual terms, negotiation history, and the amendment process. A normal businessman, when signing a contract, will take the rules he knows and is currently using as the basis. It is known to both parties that the arbitration rule in effect at the time of signing the contract is the 2016 version. The 2025 version was unpredictable at that time. In the context at that time, such a clear expression of intent should have received stable and affirmative support. Moreover, the intentions of the former contracting parties can be reasonably inferred. The tribunal can find clear evidence of this intention in the negotiation history. Honorable members of tribunal, may I guide you to review page 21 of the case file. The claimant exhibit 7. The email from Ms. Gobley of the Botanical Garden. She states, and I quote, I had a look at the arbitration of the Singapore International Arbitration Center. The current version of their arbitration rules is acceptable to us. Then, in 2022, both parties revised the contract. During the comprehensive review of
Yes,
the
counsel,
contract,
Sorry, Counsel, this is actually from the Botanic Garden company, which is not a party in the disputed contract, right? So why should the tribunal follow the intention or focus on the intention of a Botanic Garden contract?
Thanks for your question, Madam Presiding Arbitrator. When the respondent undertakes the contract for the botanical garden, it cannot simply inherit the contractual commercial benefits. Instead, the respondent also inherits all negotiation history and mutual understanding of the contract. When assuming a contract, the successor is obligated to investigate the context of its terms. The respondent claimed that it was unaware of the party's original intent to apply the 2016 rules is untenable. If my answer can fit your questions, can I go on?
You may proceed.
Okay, thank you. Then, in 2022, both parties revised the contract during the comprehensive review of the contract. The respondent did not propose any amendments to the arbitration clause. It indicated the respondent agreed to the agreement on the arbitration rules in the original contract. Next, claimant arbitral tribunal to specify in the customized dispute resolution procedure that the SIAC rules 2016 should apply. The clause creates a single integrated dispute resolution process with mediation as its first step. This was a deliberate modification of the standard ARP-MED-ARP protocol within the 2016 framework. As held in the case Lincoln Henry versus Tunneling Club, where a mediation is a mandatory pre-arbitration step, the arbitration proceedings commence when the mediation begins. Here, the claimant initiated mediation in 2024, presenting its core claims and engaging in substantive discussions. This was the substantive commencement of the contractually agreed process. That date falls entirely within the realm of the Rules 2016, giving effect to the parties' legitimate expectations. Also, when claimant filed its notice of arbitration, it expressly proceeded under the Rules 2016. SIAC's own commencement letter of August 8, 2025, then provisionally applied the Rules 2016. This reflects how both the parties and the institution itself understood their agreement. For all these reasons, we submit it is dispositive that the SIAC rules 2016 govern this arbitration. If the tribunal has no further questions, I will now proceed to my second submission.
Yes, Counsel, for the commencement of an arbitration, normally we will see the notice of arbitration being presented, right? So you are arguing that this arbitration clause is kind of a single integrated process, but can you provide us with more source of law or precedents to say that actually, the commencement of an itself is equivalent to the presentation of a notice of arbitration?
Okay, thanks for your question, Madam Arbitrator. First, I want to quote the similar case, Dynajet versus Wilson Taylor. It's the Singapore High Court's case. And in this, it is also that a multi-tier dispute resolution clause constitutes a single arbitration agreement. We think that if our arbitration, we submit the arbitration should commence with the mediation as the first step. When the mediation commences, we think that the tribunal should go on with our decision.
You may proceed.
Okay, thank you. Now, coming to my second submission, we request the tribunal deny the respondent's call for disclosure, and the claimant has 4 points to make. First, the tribunal lacks the power to such disclosure. As we have established, the SIAC Rules 2016 govern this arbitration. Under the SIAC Rules 2016, the arbitral tribunal possesses neither explicit authority nor established practice to support such extensive disclosure obligations. Meanwhile, no Danubian interpretation has permitted a tribunal to compel disclosure of a third-party funding agreement. This position is reinforced by the Danubian Supreme Court, which upheld an award when the arbitrator rightly refused such a request for lack of powers. Second, even if the tribunal believes it has a dictionary power, it should not be exercised in this case. Here, the opposing counsel stipulated that the tribunal under SIAC Rules 2016 had a broad discretion to order disclosure. However, the tribunal's authority was bounded. It is also constrained by the agreement of the parties or the relevance and the necessity of the evidence. The funding agreement is irrelevant to the substantive issues in this dispute. As the tribunal held in Oxford versus Uzbekistan, the terms of a funding agreement are typically irrelevant to the proceedings. The respondent's reliance on vague news articles about our founder's reputation is not sufficient to meet the high threshold for this intrusive request. The respondent...
Counsel, I have a question. However, the respondent just cited Article 27 of SIAC rule saying that has the authority to order the copy and document in their possession, which has the material effect to the outcome. And the respondent also argued that the third-party funding agreement is vital to the outcome of this case. Why isn't it important that in your mind that the third-party funding agreements is not relevant to the proceeding?
Okay, thanks for your question. First, if we use the SIAC Rules 2016, the tribunal do have the dictionary power but here there is no explicit authority and there is no established practice to support such extensive disclosure obligations. Although it will harm our claimant's rights, I will consequently do submission. Can I go on? Okay, thank you. The respondent's argument conflict the existence of funding with insolvency. They allege that ATJ is a raw funder without conclusive evidence. And based on this, they conclude that the claimant lacks solvency and that the fund refused to cover adverse costs. In doing so, they are essentially treating the existence and disclosure of TPF as an indication of the claimant's financial status. Honorable Tribunal, this contradicts the SIAC rules, Article 38.5, they themselves. Furthermore, in the precedent PCA case, South America Silver versus Bolivia, the tribunal rejected the application for security for costs, holding that the mere existence of TPF is insufficient to justify an order for security for costs. From a proportionality perspective, the potential harm Okay, thanks for your question, Mr. Arbitrator. First, we use the precedent PCA case just to give the evidence that there is the case and the word that support that the mere existence of is insufficient to justify an order for security for costs. If the tribunal think there is more evidence need to be submitted, I can use another case. The ICSID case, Eurogas versus Slovak Republic. The tribunal made it clear that financial difficulties and funding, which has become a common practice, do not necessarily constitute per se exceptional circumstances justifying that the respondent be granted an order of security for costs. So if my
Okay, Clement, you can answer this question, then finish your argument, okay?
Okay, thanks for your question, Mr. Arbitrator and the presiding arbitrator. We think that this case is just an evidence that the other tribunal can take in account. And also, we think that today here the SIAC can just use it as an evidence or some other support. So if you think, but also the power, the ultimate power is rests on you.
All right, then we'll come back to respondent. You have 1 minute for rebuttal. Okay, let's start now. Mic on, please.
Oh, sorry, Madam Arbitrator. Just one point to rebuttal. Respondent would like to clarify a misunderstanding that respondent is not using the existence of third-party funding as an indication of the financial status of claimant because claimant is already in a serious financial difficulty. Respondent is worried to the reputation of the third-party funder and the lack of transparency, ATJ funding and lead sure is unwilling or incapable to bear the adverse costs, if any, and that will cause the economic loss of respondents. And that's a reason why respondent is considering to file the potential security for costs. Thank you.
All right, then now we'll have a claimant. You have 1 minute for rebuttal, please.
Okay. Madam Presiding Arbitrator, Honorable Tribunal, the respondent mischaracterized our position. The procedure is on the disclosure, respondent still shows no concrete relevance. They use the transparency to battle our position, but also we have already provided all the information needed for conflicts. Anything further is intrusive, unnecessary, and strategically harmful. And also, claimant has already voluntarily disclosed all the information required for the checks. So the other request will harm our interest. Thanks.
All right. Okay, now we will come to our merit part, and we will start with claimant, right? So we will have, 14 minutes. Sorry, just bear with me. We will have 40 minutes for the presentation. Okay, claimant, please.
Madam Presiding Arbitrator, members of the tribunal, and also the opposing counselor, thank you. And now I will make my client's submissions on the law applicable on the merit. On issue 3, we submit the respondent is not exempt under Article 79 CISG as it has set 3 hurdles. First, an impediment was not reasonably foreseeable at contract conclusion. Second, which was beyond the party's control. And third, the most important one, which could not reasonably be avoided or overcome. However, in our submission, none of these requirements is satisfied. Respondents' non-performance results from its conscious commercial decisions. First, respondent accepted a foreseeable regulatory risk. Under clause 4.2 of the sales agreement, if you may say, that's the exhibit claimant 2. Respondent had a right to fix delivery on any date between January 1st and March 31st, 2024. Expressly stated to be time is of the essence. Under this clause and the FCA capital city term, respondent, as the buyer, was reasonable for all import permits. Thus, respondents knowingly assumed this regulatory risk. All these clauses explicitly allocated this risk to respondent. Second, respondent abandoned reasonable Thank you, Mr. Arbitrator. Force majeure under Article 79 and under contract required that impediment render performance objectively impossible or legally buried. Here, performance was still possible. Claimant offered an early delivery solution that would have completely avoided this impediment. So, but however, a hardship means that owning the costs will become really unfair to one party. But anyway, it's not the force majeure under Article 79. And we believe their non-performance is due to their own commercial choices, not the force majeure or the government measures. Thank you. Yes, we do find a case in our, that's a Ukraine commercial arbitration made in 2012, which confirms the difference in force majeure. Thank you. Second, respondent abandoned reasonable measures and prioritized its own convenience. Even assuming that appendix 1 was an external event, Article 79 still requires that the party could not or overcome the impediment. Here, respondent chose not to use the tools it had. At the November 1st, 2023 meeting, claimant proposed delivering the orchid before the end of January 2024, ahead of any appendix 1 decision. That proposal would have avoided any change in site regime. However, respondent rejected claiming its new greenhouses would not be fully ready and that using older facilities would be commercially reasonable. However, just as the arbitrator's question, these higher internal costs and inconvenience do not fall under the conflict force majeure clause. That is a classic hardship. Also, at the same November meeting, discussed a second mitigation option. Respondent could apply in November 2023 for an import permit in advance, following the practice Equatoriana had already used in another case where appendix 1 was looming. That is in Notice of Arbitration, paragraph 12. Despite that precedent and respondent's strong local connections, it never meaningfully pursued the path. Instead, on December 2nd, 2023, Mr. Obvious assured claimant that obtaining the necessary permit, even on short notice, should not be a problem, based on his context and the authorities' past practice. This is actually not the behavior of a party faced with uncontrollable impediment. It is the behavior of a party betting their future and failed. For these reasons, respondents' non-performance is the ultimate reason for their commercial choices, not an unavoidable impediment. Accordingly, we submit that Article 79 does not exempt respondents, and they are fully liable for damages arising from their breach. And if tribunal had no more question, I will move on to issue 4.
Yes, please.
Thank you. Turning to issue 4, I will show that claimant is entitled to $3.3 million damages under Article 75 based on a reasonable substitute transaction. Article 75 allows an aggrieved party, after avoidance of a contract, to recover the difference between the contract price and the price in a substitute transaction made in a reasonable manner and in a reasonable time. Here, first, the respondents may contend that the substitute transaction was made before the avoidance of the contract. However, numerous cases and commentators recognize that substitute transaction concluded before the formal declaration of avoidance can still fall within Article 75. That is because the chronological sequence of events is not an absolute prerequisite for the application of Article 75. Under this clause, once anticipatory breach has made performance impossible and triggered the seller's duty to mitigate, a substitute transaction remains fully valid even if it's concluded before the formal declaration of avoidance. That is precisely what happened in our case. Second, the substitute sale was conducted in a reasonable manner. The vanilla orchid.
Counsel, are you arguing that this Article 75 should be given a flexible interpretation based on the commercial necessity and reality, instead of interpretation based on its wording?
Thank you, Madam Presiding Arbitrator. First, we mentioned that a lot of cases has already recognized that the chronology is not decisive factor to identify a reasonable substitute transaction. Besides, we submit that under no circumstance should a tribunal deprive an innocent party the right to recover their losses only because of several errors in procedure. This is because Article 75 does not require the substitute transaction to be concluded strictly after the formal declaration of avoidance. As there's already an anticipatory fundamental breach exists, asking this kind of procedural requirement would be too strict for the claimant. Thank you. Beg your pardon, please. I didn't quite catch your problem. Could you please repeat it again? Thank you for your question, Mr. Arbitrator. We believe that the matter is because of the good faith or the interpretation of the Article 75. We could not deprive the innocent party for the damages created by other breach. So under these circumstances, if the tribunal strictly ask the claimant to follow the procedural requirement of Article 75, it does not fit the fact that the orchids will bloom in the coming month, and we need to mitigate these losses as soon as possible. Thank you. Second, the substitute sale was conducted in a reasonable manner. The vanilla orchid was due to flower in June or July 2024. Once they flower, their commercial value drops by at least 30%, and their remaining productive life is only about 2 to 3 seasons. Also, claimant needs a greenhouse capacity for next production cycle. Therefore, claimant had to sell and deliver the orchids before mid-May 2024. Immediately after Abiel's call on February 10th, claimant approached Herbal Cosmetics on February 12th and concluded the substitute transaction on February 15th, with delivery on April later. Thank you for your question, Mr. Arbitrator. Just I mentioned, once the anticipatory fundamental breach has occurred, the claimant was entitled to mitigate the losses as soon as possible under Article 77. So also, given that there amicable relationship between Herbal Cosmetics, even if the respondent had the ability to perform the agreement again, we could terminate a contract made between Herbal Cosmetics because they did not any breach agreement in this contract. So it actually did not influence any right or obligations to the respondents. And the most important thing, they actually delivered this batch of flowers in April, and that is the period after the declaration.
So a quick question, Counselor. What is your take for the second agreement that you reached with the third party concluded on October 2024?
Thank you for your question, Madam Arbitrator. The contract with Herbal Cosmetics on October 2024 was the original contract made in 2022, 2 years ago. And these two contracts was quite different, as the former one was due to the respondent's breach and its aimed to mitigate the loss because of their breach. However, the latter
when contract was signed, whether a reasonable person in respondent's position could anticipate the occurrence of the impediment. Members of tribunal, the answer is definitely no, because the case fact shows that the site's recommendation to include vanilla oil was given out in September 2023, which is 1 year after the conclusion of the sale agreement. Therefore, the element of unforeseeability has been met. Second, regarding the sphere of control, members of tribunal, we argue that the standard of sphere of control is an objective one, which means we need to consider the objective sphere of the influence of the party. For example, the case law shows that the external events such as the organization from international, the resolution from international organization or state sovereign act can unquestionably fall outside of parties' sphere of control. And we notice that claimants has mentioned that because there is some articles appeared in the sale agreement which grant the obligation to secure import permit to respondent. However, we argue that the merely stipulation of obligation cannot be regarded as granting the whole risk of this action to the respondent side, except the stipulation of obligation is only granting the foreseeable risk. The established cases, for example, the Porsche cases, powder cases, and also the commentary from the Professor Schranzer and Stephen Crow also indicate that the unforeseeable risk in the future cannot be merely granted to one party by stipulation of obligation. And therefore, we argue that the obligation of import permit appeared in the sale agreement cannot be regarded as the this this impediment is fall within the respondent's control. Therefore,
yes, we got your argument that this is the impediment that satisfies the requirements of Article 79 CSG. But the thing is, from the attitude from the government, that is one side, but on the other side, for you, for the respondent, that you simply refusing the delivery and did not try your last resort, or did not try your best to actually to mitigate the loss from the claimant side. So does that also satisfies the requirement under Article 79, especially paragraph 1?
Path which could result in risk, but not neglect another path which is original followed by us. So we argue that both these two measures proposed by claimant's counsel is not reasonable from perspective of respondent. And therefore, the causal link issue, we argue that it is the inclusion of liner orchid and also the rejection of import permit application from the Equatorial government that render the non-performance of respondent. So hence, the full requirement has been met. We argue that respondent is exempted and claimant is not entitled to any damages here. And if this tribunal has no further question, I will move on to the next issue. Okay, thank you.
Please.
So in issue 4, the calculation of damages. Members of tribunal, respondents submit that even if the previous damage claim could be considered, claimant is not entitled to recovery by a substitute transaction pursuant to Article 75 CSG. Members of tribunal, Article 75 CSG empowers the aggrieved party to recover its loss by conducting a substitute transaction. But entitled to such remedy, at least one requirement must be met, which is the substitute transaction must be conducted after the avoidance of the original contract. Members of tribunal, in this case, respondents submit that the contract was avoided by email from Mr. Theophrastus on 1st March 2024. However, the alleged substitute contract to resell the liner orchids between the claimant and Herbal Cosmetics is conducted on 5th February 2024, which is a half month before the events. We notice that claimant has alleged that if there is an exception on the timing requirement, which is if there is already any definite refusal to perform or anticipatory breach, the substitute transaction could be conducted after that time. But members of tribunal, we argue that this argument is constructed on the wrong interpretation, both legally and factually. First, the established cases have the opinion from the CSG Advisory Council indicates that such requirement is a stringent requirement and no exception existed. And we also notice that from the question from Mr. Arbitrator, the text interpretation should be the first method we should turn to according to the VCLT, which is we must focus on the textual meaning. And from text of the CSG, there is no requirement existed in this article, which is Article 75. And we argue that even if exception existed, claimants misinterpreted the statement made by Ms. Albius, which does not constitute a definite refusal to perform or anticipatory breach. This is because, if I may quote the statement made by Mr. Albius, which is, it would be impossible to obtain the required import permit within the period required to meet original delivery date. And to my big surprise, he also expressed doubts about whether it would be possible at all to obtain the permit under new circumstances. End of the quote. Members of tribunal, this does not amount to a definite refusal to perform because it requires a high level of clarity and precision to decide a definite refusal to perform. And in this statement, first, a delay in performing does not equal to refusal to perform. And second, expressing doubt is not clear, and expressing doubt is not a clear and definite refusal. So here, respondent merely pointed out that the practical difficulty of obtaining an import permit and expressing the respondent is merely pointed out that there is a practical difficulty and there is uncertainty of obtaining import permit. Yes. Since my time expired, Mr. Arbitrator, may I first answer your question? Yes, so I will first answer the question very specific. Mr. Arbitrator, we understand that the statement made by Mr. Albius is declare some intent from respondent that we cannot fulfill our obligation in time or conform to the original stipulation on the contract. But we argue that the point we argued by respondent here is that the definite refusal to perform is require a very high standard, which is we must clearly declare that the intent of non-performance. For example, the cases like the German good cases and the GM's module case that indicates that the statement, for example, with the conditional avoidance or just a complaint about the non-performance of the goods does not constitute a definite refusal to perform. So we argue that in the case at hand, there is no definite refusal to perform or anticipatory breach on that date before the substitute transaction has conducted. So therefore, we argue that the claimant's transaction with the herbal cosmetics cannot be entitled to the recovery under Article 75 CSG.
All right. Okay. Since the respondent took more time in terms of answering questions, I will add certain for the claimant for your rebuttal. Okay. So now let's start for now.
Thank you, Madam Presiding Administrator. First, this impediment is not a force majeure. Indeed, the site ban take immediate effect, but it never affect delivery goods in advance or get an import permit in advance. These are both approachable alternatives. However, the respondents refuse to take these proposals. They mentioned that there is some cost losses or other burdens to perform. However, this might be a hardship, but it can never satisfy and force measure under Article 79, as there is still possibility to perform the contract. Also, while the under Article 75, the chronological sequence is still a controversial problem. However, also as the respondent had mentioned in AC opinion number 6, it is reasonable for the performing party to reach an agreement before the declaration of avoidance. Scholars and arbitral tribunals consistently affirm that CSG looks to economic causation, not formalistic sequencing, like the case in Poland, glass crushing machine case in German, and Italian grape juices has already confirmed this kind of functional sequencing. It is certainly unreasonable to deprive the performing party of its right to remedy solely due to some minor defects. Thank you.
All right. Now we have the respondent for your rebuttal, and you only have 1 minute. Okay, so start now.
Thank you. 1 point for the rebuttal. Members of the tribunal, we do not argue that the loss of taking early delivery is intolerable. What we argue that is at that time, our client does not realize that there is an immediate effect of the inclusion of line orchids. And because the two passes, one is taking a delivery, which could result in loss, and another is follow original arrangement, which we followed previously, will not result in losses. So as a reasonable business person, our client definitely will follow the first pass, which is the original delivery date. So we argue that at that time our client could not reasonably take in such measures. So it is not the deduction from the losses, the amount of losses, and that concludes my rebuttal. Thank you.
All right, great. So right in time. All right. I think now we have concluded our hearing, right? So congratulations to both parties that you have done an excellent debate. All of you have demonstrated high standards of professionalism. So for the next 5 to 10 minutes, we will invite our honorable arbitrators to make some comments. So we will start from Ms. Zhou, please.
Sure.
nicely done, everyone. I will just comment from the claimant to the respondent then. So to the claimants, wonderfully done. One small suggestion is that when you are doing the presentation, you are suggested not to read from the text, but maybe to speak it to the tribunal so that the tribunal may have eye contacts with you and we get more involved. And secondly is the legal basis, which is the question that has been asked by all three arbitrators. What is the legal basis to your answer? So you may want to work harder on that part. And to the respondent, Nestle, Dan also, both of you have very good timing and technical issues do present and nice teamwork so that the other teammate who is not presenting could mute or unmute the microphone. So nicely done. I will save the time for my wonderful teammates.
All right, thank you. And we'll have Mr. Kamuka. Am I pronouncing it right? All right. Thank you. Thank you, Mr. Kamko. Well, I concur with my colleagues in terms of their on both teams. One thing to add is that I would suggest both teams that before you present your argument, it will be better if you can give us some like the roadmap of your argument. I think the claimant has to especially has to do that in your following up competitions, because sometimes we might miss in your argument, and for the respondent as well. Especially I have to point out that I'm quite satisfied with the respondent, the second team player, Mr. Tan. I'm very applause to you, because it seems to me that you're quite mentally resilient, because you're ending the time, the countdown, and you still answer a question in a quite clear way. So that is something that the lawyer or good researcher has to have a good quality for lawyer. So I can see that all of you have good language ability, and you have good appearance, quite diplomatic in sitting here arguing, debating. So applause to you all that you have done a very good job. Okay, so I think now this arbitration is adjourned. All of the counsels, now you can leave the room. Okay, so before we leave the room, should we have a picture together?
Oh, yes. Thank you so much. And I'd like to invite all the participating teams and arbitrators to take a selfie Photoshop, and let's straighten up our appearances. And I will take a shot. Thank you. Okay, that's nice. Thank you so much. And now the participating teams can leave the Zoom.